The agenda for today's work session is based on the Reform Committee's recommendations and options. And I'm going to now turn it over to Shannon Callahan, who will run through the Reform Committee's options that they've come up with for us.
If it's all right, I'd like to address the second item actually first of the pension system, if that was acceptable with council to move that up to the first agenda item. The committee submitted that pre-funding the normal cost of the pension going forward would provide a more fiscally responsible pension system. It was the committee's belief that moving all hires into the PERS OPSRP pension system would provide significant savings to the taxpayers over time. However, the committee did not believe that entering the Social Security system was a good option either for the taxpayer or the beneficiaries, and felt that an additional contribution to the individual account plan, the IAP portion of OPSRP, would be a better financial option. And that's the first discussion point for council.
So in effect, since the city already contributes 6%, the city would contribute 9%. Is that correct?
The council can choose to contribute extra in a negotiated agreement with the associations between 1 and 6%.
I think the numbers that have been discussed over the past couple of weeks have been a 3% contribution to the IAP.
Discussion from our council members.
That's in addition to the 6% to normal contribution.
That's correct.
Like a deferred comp kind of an account.
IAP.
And what is that individual
Account plan.
account plan?
It's the defined contribution element of the OPSRP pension system.
And what is that exactly? Is it an investment fund? Is it?
I think a similarity in the private sector would be similar to a 401k.
Okay, so it'd be like, yeah, all right. So it's like a deferred compensation.
And the member can also make a contribution.
Okay.
Would you like to proceed with the disability portion?
The Reform Committee actually forwarded two approaches to reform the disability system to council. The first was the Workers' Compensation Plus package, which made some additions to the workers' compensation system. I believe that all of the council members have received a memo from the city attorney indicating that there are some significant legal and administrative issues with moving current individuals into the Workers' Compensation Plus package. The committee also offered a prototype for reforming the current FP&R disability system, making changes to both the decision-making process and to the membership of the board from a current 11 voting members to 5 voting members. The committee submitted that the first member should be a representative from the Police Association, the second from the Fire Association. 2 citizens should be appointed by the mayor, subject to council approval. And the next member, the 5th board member, would be a representative of the city. The committee did not did not proffer a consensus on that, but offered some suggestions or guidelines to council. They believe that it should be a city position, someone at the city to maintain a close connection to the city. They felt that it should be the mayor or the mayor's representative or a named member of the city's management team. However, they felt that this member should not be a past or present member of the FPDNR system, nor have been employed as a Portland firefighter or police officer. Those were the same parameters they gave to the citizen members as well to ensure that the Board of Trustees was an independent system.
The 2 citizen members would also have, quote, relevant experience.
Yes, they would.
Meaning disability or pension expertise, or both.
That's correct. So the first discussion point would be the 5th member of the Board of Trustees. If you were to choose that.
And the options are again?
The mayor, the mayor's representative, or a named member of the city management team.
Are you including that as one, or is that the 3 options?
Those are kind of 3 options, and I think you could do with them as you choose. But those are what the
options
for the one position for the 5th member.
But I would assume it would have the same conditions as the other appointments by the mayor, and that is with the approval of the council.
Right.
Different than the way it is now. I mean, the mayor's a member of the board by virtue of being the mayor.
The chair of the board.
chair and a member
and a member.
by virtue of being the mayor.
Correct.
And I actually think that that makes some sense.
Are you a voting chair or only in a tie?
I'm a voting chair. We had that discussion at the last board meeting, and that's how it's always been. I mean, even all previous mayors have been the chair of the board or their designate. Austin is my designate if I'm absent.
Well,
I don't know why we would change that from the way it is now.
Well, you know, I can live with either one.
I'm sorry?
So I can live with either one, but I just thought that as far as, you know, if it includes a member who's not a beneficiary, you know, I would not be able to be that person.
Well, but I don't think that that's appropriate. I mean, the mayor is the mayor and is elected, understood by the populace of coming to the council with whatever background the mayor brings. And I don't think anybody would argue that's been a problem since you've been the mayor. And I would remind everybody that you're the second mayor that was a beneficiary of the fund, the first being Terry Shrunk. I don't think that was ever a problem.
That's right. Forgot about that.
Chaired the board for 16 years, and I think it's an important connection between the elected officials, and I think actually that kind of a model is something I'm thinking of for our other quasi-independent entity that exists via the charter. So I think it makes sense.
So the Reform Committee, they did signal this position, though, as not being a beneficiary. Right?
They did.
So they did highlight that.
They felt it was important to have the board not controlled by beneficiaries.
And I can understand that perception issue, and it doesn't bother me. But I think we could put someone in there that I think would represent the city council, whether it's a bureau manager or one of the other council members.
Well, I think if you're allowed to have a designee, then you wanted to write something that you had a designee, that's fine. But I don't think you write charter proposals for who's in office today, and that's what
It's
this
true.
sounds like. And I don't.
It happens once every 40 years.
Yes, and I don't think. I think that it's important for the citizenry to have an elected official on these quasi independent entities that are created by the charter, and I think to the extent that we don't is a problem. And I naturally would seem to me that'd be the mayor, would be that person.
The other members' thoughts?
Well, I don't think it has to be the mayor. It could be the mayor, so I would go with the mayor or the mayor's representative.
That's what I meant.
That's currently
That's
as-
the current language, and that's what I meant. I think it should be up to the mayor, just as it is now, to a point. When I was on the board for 12 years, and Mayor Clark never came, towards the end of Vera's term, towards the end of, my term, she began occasionally coming. So it's more unusual for the mayor to be there than not, and normally has a designee. As you know, you were on the board.
And
I guess I would envision the mayor's representative being broad enough to go beyond personal staff, though, to include.
No, the
Management.
Mayor Katz had,
chief of staff, wasn't it?
well, no,
Was it Sam?
No.
Who?
no, Paul Elsner, thank you.
Oh, from
who
the
was
city
not
attorney.
a member of her staff, who did not work for the city.
But we had to make him a member of the staff for $1 to get him on there. So make sure that the details reflect that it's or your designee, whether staff or not. There was some interpretation at the time that we had to pay him $1 a month in order to make him a staff person so he could be appointed.
Well, it sounded like or designee.
And would that designee then be approved by the city council?
Hasn't been in the past. I mean, it doesn't bother me that it is, but that's not the way it has been. I mean, that would be a change, so that's fine.
I could go now.
Well, and it also makes it public. I mean, in the sense that it
Yeah.
goes out and it's people vote on it and it's public record. So a little bit
And
more
it should be a
transparent.
consistent presence. Whoever the person is, it shouldn't jump back and forth to, well, it's Tuesday morning and, you go, and the next time it's somebody else. It should be a consistent person.
So what we're doing with the fifth member as opposed to the third and fourth members are that the fifth member, we leave the mayor the discretion to appoint an internal candidate, whereas the two citizens clearly are external candidates. But you could, so the fifth one just gives you flexibility to look inside. Is that the difference?
That's my understanding.
That's fine with me.
Next point.
The next point was something that was not addressed by the committee, but was acknowledged by the committee as an issue. Currently, right now, the city auditor plays 3 roles in the FPDNR system. The first is not a charter mandated role, but his office supervises the administration for purposes of city management. Secondly, the auditor's office, the auditor currently maintains a position on the board, but that would be taken care of if you were to go to this 5-member board. And the third issue is actually a charter requirement that the auditor, along with the board of trustees, has the authority to appoint and terminate the administrator. I don't know if Gary's here today, but he indicated that he needs to be completely independent of the FPDNR fund system to comply with government auditing standards to be able to conduct independent audits of the system. And so that's where the administration comes up. If you were to remove the auditor's name, there obviously is a charter change needed for the administration.
I would like to see us consider, it's my suggestion that the administrator become basically the equivalent of a bureau director appointed by the mayor with the advice of the board and subject to council approval.
Advice and consent.
Advice. Subject to council approval.
So in other words, you're saying that the mayor just picks who that person is.
With the approval of the council?
Yeah, with
Approval of council.
approval of council and the advice of the board. And it becomes a direct report.
What was the
Yes.
recommendation of the committee?
They didn't really say anything, I think.
It was discussed, but there was the committee acknowledged what I brought up to you, but there was nothing the committee decided to forward to council on this point.
It seems like it works pretty well now that I think the auditor and the pension board, the board of trustees, jointly agrees and hires the administrator, and likewise jointly agrees on discipline or termination. I think that's pretty good. My experience has been that's worked pretty well for all sides, and everybody feels included. And I would suggest that we do the same thing with the auditor being replaced by the mayor, and they be, as opposed to the board advising you, that there be advice and consent, that there be a consensus on who that person is.
Could I ask a clarifying question of the role of the fund administrator moving forward? Would that be to you? Does the
Yes.
fund administrator, the fund administrator's role moving forward is what exactly?
In regards to the pension system, and I think Babette could actually probably speak about what she currently does in the pension system, but it's a somewhat more limited role for, I think, helping the board certify the pension system. Under the reformed model, under the disability system, the administrator's role changes. Right now, the administrator makes recommendations to the board of trustees, who's the first decision maker in the claims making process. Under this model, the administrator would be the first decision maker. It would empower, the reformed model would allow the administrator, similar to a workers' comp style, which is where the first decision maker is an administrator, professional administration. Did that make sense? Did that answer your question, or I just can?
So the fund administrator will be making decisions on individual claims?
Yes.
Okay. And your suggestion, Randy, again, was that the fund administrator be hired with the concurrence of both the board and the council?
Mayor, the way I think the way
Appointed by the mayor or nominated by the mayor?
well, I think the way it works now, and Babette, correct me if I'm wrong, is that the hiring is a joint decision between the auditor and the board. And I don't think the council's involved at all currently. This would change that to the council and the board agreeing to a pick, and then the council would confirm that. And I think that makes some sense.
I'd like to see it more sequential if we're going to go that way. I'd still like to see the mayor nominate, then be approved by the board, and then be approved by the council.
I think it has the same effect.
Because the person will now clearly be working no longer for the board, but will be working for the mayor.
But I think that has the same, I mean, the idea is that everybody feels bought in, and that's I think, in some sense.
So nominated by the mayor,
Nominate by the mayor,
approved by the board, approved by
by the
council.
board, confirmed by the council.
Confirmed by council.
So we're just confirming basically what the board and, what the board and the mayor bring to us.
And then the administrator would now report to the mayor.
Report jointly to the way that works now, and I'm assuming would be the same, that person is responsible to the auditor and to the board
The auditor currently has the firing and hiring.
with the board's concurrence.
Yes. But that means the auditor that initiates
Yes.
the action.
Yes.
So the mayor would initiate that action. Which means that I assume then that the mayor would be the supervisor of that individual.
I think that's pretty much the way the system is considered to operate now.
And that it
Well, I
would
mean,
be,
with the
be the
auditor.
equivalent, as Commissioner Salzman said, of a bureau head.
That's right.
Okay. Any problems? Dan?
No, that sounds good.
Okay. The next issue.
Those are actually, if you,
Sorry, can I interrupt? I just want to be clear on what you're asking.
Just please sit down. Yeah. Thank you.
Did you want the
State
same?
your name.
Linda Meng, City Attorney's Office. I just want to clarify if you want the same procedure for removal as for hiring, because that didn't come through clearly, so.
How does it work now? Do you want to come on up? Why don't you come on up?
Hi, Babette Heffley. How it works now, the charter does provide hiring and firing, I think,
Okay.
by a joint decision of the auditor and the full board of trustees. If that helps.
Yeah, I think it works pretty good that way now.
Now, what would happen if there was a difference? So let's say the supervisor said, the mayor says this person's got to go, and the board says, well, we don't think so. That's never happened to my knowledge.
So, I mean, as a practical matter, I'm not sure that's an issue, but, I mean, you would have
Well,
to somehow figure out how to work that out.
There has to usually be one
Yeah, I
final
guess-
authority on this.
I would like to see, I mean, the hiring, I think we've got a good sequential process, but I do think issues around termination need a clearer line of authority. And there's a potential gray area here if we follow the existing model. So I would, again, propose that the mayor have the firing authority.
If the mayor is the supervisor, I would imagine the mayor would have to have that kind of authority, as they do with the bureau director now. A commissioner does.
But again, the hire would be subject to the board's approval and council approval. Any hires.
and this might just not even be an issue, but it just seems to me that the fund works pretty well in that way now, that the management of the administrator by the board of trustees and the auditor seems to work pretty well now. And I don't think, I'd hate to get into some kind of a politicalization at some point in the future of that position. And I think kind of having that balance makes it less political.
Well, what about with the advice of the board? Not the consent, but the advice, so that,
Yeah, I
that
think
the mayor has to approach the board to discuss the issue.
I think
And
as
that's
a
also
practical-
a public record as well.
I think as a practical matter, that would work well.
I think also as a practical matter, if the mayor does not have, what we also don't want is the mayor not having trust in the administrator before they hang on. That's, I think, what you described is probably the best hybrid of the three options.
So this would give, I mean, what we're talking about right now would give the mayor the ability to terminate, seek the advice of the board in that decision, but still the mayor's.
Correct.
Yeah. I think we've really dealt with all of sort of the issues.
Well, I mean, Austin and I discussed yesterday this issue of the age 53. There's a significantly different retirement age for public safety officers under OPSRPS 3 than the current system. So age 50 to age 53. What I'd like to explore what the thoughts are on that. And if there's any.
Well, I think what we were looking for was a bridge to sort of ensure that there was an equal to or better system. Is that right?
I don't know. I mean, I haven't been part of that. I mean, that's a whole different discussion when you add up all the benefits here and compare it to at the sum total of all the benefits there. I'm specifically focused on the age 53 as a major policy change.
Isn't our IAP contribution designed to account for that in part?
I would actually defer to some questions on this with Ken Rust, but there's one thing that was a misconception that was cleared up during the Reform Committee process, which is that retirement is allowed under the OPSRP system at age 50 for public safety officers. It is an exception that doesn't exist for other classes of workers. 53 is the normal retirement age for other classes of workers, but 50 is allowed for public safety officers under the OPSRP system.
And so they would begin retiring at their full amount at age 50.
Do they have this sheet? Because it certainly indicates that they would be just slightly above that, Randy. Do you have that? Does everybody have this one sheet? And it says wage and salary replacement ratios based on 25 years of service, assuming no participation in Social Security. And you go over to the 9%, which is the 6% plus the 3%.
Right.
And you
Again?
the this one page here. Do you have that?
I don't believe I am
Could you
looking.
get
This one right here?
Yes. Move over to the total,
He's on 25.
which is it's the fourth in from the right. It says 9% IAP,
Okay.
and you follow it down, and you see the current FPDNR is the first category is 62.3 for fire captain, firefighter, police sergeant, police officer.
Searching for the 62.3.
It's right here.
Okay. Oh, up at top. Okay.
Yeah.
Gotcha. All right. And what does that represent, 62.3?
But that's at age or at 25 years of service. That's the retirement benefit. Equal
At 25 years
at
of service.
25.
And age 50 or 53, or does it matter?
It just says 25 years of
It
service.
doesn't matter.
There's not a haircut under the FPNR system after you reach.
Oh, this is
50
the
or
FPNR
25.
system.
That's
I'm
the
sorry.
FPNR system. on the
Okay.
first one. That's
So the next one then is the OPSRP pension plan options, and assumes 6% earnings, which is a conservative estimate, but it actually gives a 62.7%, which is higher than the FPDNR. Is that correct, Ken?
For the record, I'm Ken Rust from OMF. That's correct, Mayor, but I believe the numbers that were run by Milliman assumed the pension benefit that's shown here along with the IAP benefit based on a normal retirement age. By that I mean a retirement that would not result in an adjustment to the monthly pension. Under the OPSRP program, if you retire after age 50 but prior to age 53, there is an actuarial adjustment to the pension benefit. to take into account that you're going to get the same pension dollars but distributed over a longer time period. That is different than the FPDNR system, which is at 25 years and at least 50 years of service. You get a pension benefit that does not have an actuarial adjustment. But you have to work at least until you have 25 years of service before you can take any pension whatsoever. In the OPSRP plan, as long as you have 5 years of continuous public safety service prior to reaching age 50, anytime after age 50, you can take early retirement in their system with an actuarial adjustment. So there are some differences in terms of what the pension might be, and there are some differences in terms of how it may affect a particular member based on their circumstances after reaching age 50. But the numbers shown on this page do not reflect an actuarial adjustment. They reflect a pension benefit at a normal retirement age under OPSRP.
And that FPDNR, the accrual ends at 30 years.
That is correct.
Under OPSRP, it can continue beyond the 30.
Yes, until you reach mandatory retirement age of 70 and a half. So you can, every year you work beyond 30, you continue to accrue a retirement benefit. So
do they have in the OPSRPs, do they accrue like a credit as in the normal PERS system, like 2% a year?
I believe it's, for public safety, it's 1.8 times years of service.
1.8.
Yeah.
So is the final average formula computation the same as in the other PERS too?
Yeah, there's been some changes in OPSRP relative to other tiers inside of PERS, but it is a final average salary basis, and it does allow a roll-in for average overtime pay to that class of employee, which is also different than the FPDNR system, which does not take that into account. So there are a little bit of apples and oranges in terms of what constitutes final average salary and what the formula is that's applied against it, because OPSRP has a pension benefit, the defined benefit formula, plus the IAP component. The sum of the two equals the total pension benefit. Mm-hmm. For early retirement, by that being prior to age 53 under OPSRP, after age 50, the IAP portion of the pension benefit is not reduced or adjusted actuarially. It's only the formula-based pension benefit that is adjusted.
But then those other benefits that FPDNR does not have, including accruing after the 30 years. And what was the other part, the other benefit that I wasn't aware of?
Well,
you don't have to work 25 years.
You have to work 25
5 years and a minimum age of what?
50.
50.
I think that's the way FPDNR is as well. It's a 5-year vest.
Right, but you have to have at least 25 at 50 before you can take any retirement. For example,
if you get it at,
if you had 20 years of service and you reached age 50 and you wanted to leave service and go to work for another agency, for example, you could take your pension benefit actuarially adjusted inside of the OPSRP program and go to work someplace else. Under FPDNR, if you had 20 years of service, you wouldn't be able to take
55.
You have to wait till 55
right.
or get that 25 years of service. So there are, depending on your circumstances, there are some you could view either positives or negatives regarding the minimum retirement age and the early retirement age and the years of service required to be able to retire.
So I don't know about anybody else, but I'd like to hear from the beneficiaries what their reaction to this is before I make a decision.
Okay, is there any other information you wish to share, Ken?
No, I think with respect to that question, that's what
Okay.
this sheets show you is what that pension benefit looks like.
Thank you.
That's helpful.
Now, who is it that you wish to have come up?
Just whoever has an opinion about this, one way or the other.
Look. I sit next to him.
Good morning, I'm Robert King.
And I'm Paul Cora.
I just want to thank you for struggling through the question that's really the topic of discussion right now. It's this whole notion of the IRC recommendations of no net loss in benefits, and what is the comparison, the apples to apples or the apples to oranges comparison between FPDNR's pension and the OPSRP pension. The one thing that stands out to me, and you've talked a little bit about it, is in FPDNR, it is, as you know, a defined benefit, and after 25 years of service, you're eligible to retire at age 50. And one of the questions, part of the discussion that we had in the Reform Committee was, what's the difference in the OPSERP benefit, and how does it compare? And one of the differences that stands out probably most dramatically is that the retirement age, and we've talked about this before, is age 53. So it's an increase in the minimum, it's an increase in the retirement age for a retirement benefit that's you'd consider a full benefit. It's true that at age 50, with whatever years of service, you can retire and you receive a reduced benefit, what Ken referred to as an actuarially adjusted benefit. What I'm struggling with is if in FPDNR you can work 25 years and retire at age 50, and there's a 74% income replacement, that what I've been trying to move us towards is in OPSERP, if you were to work 25 years, that at age 50 you'd take less money for the rest of your life. And so what I was encouraged by was your discussion about the 3% contribution into the IAP. I don't really know what exactly that does, right, in terms of the benefit or the payment to the individual. What I'm hoping to understand better today is is it possible? Are we talking about constructing a bridge, right, or is it possible to construct a bridge where the person who works 25 years in the OPSERP plan is eligible to retire at age 50, and they retire with a full pension benefit? I think that's the perspective I've looked at it from the notion of the IRC recommendations, not to lose any benefits. I'm not sure how we do that, but that's really the one. I understand some of the differences that Ken's explained, but from that standpoint, I'm just trying to understand how we can be confident that the OPSERP benefit.
Well, as I understand it, the 3% that is being explained would go into individual accounts, would augment the actuarially reduced payment, so that would be the bridge. I guess that makes it more relevant.
That's my understanding, too.
That makes it more relevant than the larger question that the mayor addressed, which is, did we do an actuarial balancing, Ken, between the OPSERP's plan and the FPDNR with the 3%? Is there a value number that compares those two systems? Absent disability, just the retirement?
If I understand the question, I think that the tables try to show that. We do have on the particular chart.
I'm just looking if you have like a number.
Yeah,
in the past, they've used like 135% of the value of PERS. Do we have such a quantitative?
What we've tried to do is show the potential retirement benefit, what's called the replacement ratio at retirement under different years of service, 25 or 30, with different levels of contribution to the IAP, and that IAP account earning different rates of return. So it gets a little bit complicated. The 25-year example, which is the sheet that we were looking at, shows a 9% IAP contribution, so the 6% plus an additional 3, at 25 years of service with no actuarial adjustment, assuming a normal retirement age of 62.7. Now that compares with what would have
62.5 or 7?
62.7. That compares to what would have been available to a member in the FPNR system at 62.3%. Robert, I think you mentioned the 74 number. That's a 30-year retirement age. This is the 25-year number that we're talking about.
I thought the 74% was 25 years.
No, that's 30.
84 is 30.
84 is 30.
Well, and that gets confusing too because of the way Milliman ran the numbers. And there was a discussion about how he values final average salary, which all factors into this. But the 30-year number over here is the 74.7. His number is 62.3 on a 25-year basis. And there's a reason that we had walked through with the committee, I think, why it was a different number. But the point being is that depending on the rate of return, for example, at 6%, which is an assumption that typically is lower than what actuaries use for a lifetime of potential earnings in an account like this, you'd be at the 62.7 number. So arguably, there's some
2.7 of your final salary.
of the final salary. So arguably that keeps you whole except for this early retirement and actuarial adjustment. And the question is, how early do you retire? Do you retire at age 50, 51, 52, or up to age 53? Because that makes an impact. And if you earn a higher rate of return over the lifetime of your account, that has the potential to increase the replacement rate from the IAP side as well. So, for example, at an 8% rate of return, which is the one that actuaries typically use when they make these long-term projections, the final average salary would be 68.4%. So, arguably that's higher than what it is under the FP&R
Is that
system.
inclusive of the 3% IAP?
Yes.
Inclusive of
That's the
that.
6 plus the additional 3. Earning 8% for its life would produce a retirement benefit without an actuarial adjustment of about 68%, which is something greater than what they've projected for the FP&R
Without an
system.
actuarial adjustment.
Without an actuarial adjustment. So the question is, the actuarial adjustment would absolutely reduce that. The question is how much, and that's a function of how early the retirement date
Say
is.
age 50.
I think the actuarial adjustment is similar to what they do under the PERS system, and for early retirement, and that is, I think, ranges around 8% a year.
I was going to say, I did some just rough numbers myself, and I came up with 10%. 10.
Actually, it's 11.13. If you're talking about OPSERP,
Yeah.
OPSERP, since it went into effect in 1996, and there's 9 years of data, that OPSERP level has an average return of 11.13.
We're talking about a different
different
number.
thing, yeah.
You're talking about the rate of return. We're talking about the offset when you retire earlier, how much you lose.
And I think the PERS hasn't calculated that yet. They haven't done a survivor study, which is the basis for setting up the actuarial adjustment, because the OPSERP system is pretty new still. But there will be an actuarial adjustment, and the earlier you take the retirement, the larger the
Did you take the fixed amount,
You're taking
the actuarial amount, which, just so this can be a little confusing, so I kind of wrote it out. So if you retired at age 53, the actuarial table, just for argument's sake, says you'll die at age 75. So you take the number of months that you have actuarially projected to live, which works out to be 286 months. And you multiply that by the amount that you retired at, the full amount. And for my calculation, I did $3,000 a month. That means that you'll draw, actuarially projected to draw $858,000 from age 53 until you're projected to die at age 75. If you retire at age 50 and you have the same actuarial number value in the account, the $858,000, but you have to spread it over 36 more months. Mm-hmm. So instead of spreading that amount over 286 months, you spread it over 322 months, which reduces the benefit from $3,000 to $2,700.
You get the exact same dollar benefit, but you get it distributed longer. The present value is the same, the monthly benefit's lower, and what you're going to try to do is live longer than when they say you're supposed to die, because then you really do win if you can do that.
And the other issue is obviously after 30 years, you can continue to accrue benefits. So that's an addition that
But you have to
FP&R
work
doesn't have.
longer than 30 years.
Well, but the point right now is the average age of retirement is 53 in the city for both police and fire. So they do work those extra 3 years on the average.
I was talking about the 30 years. If you work the more than 30 years as a benefit, that's
How many years did you put in?
25. So at the end of 25 years, those stairs started getting steeper and steeper and steeper.
Mayor, I know that there's a complexity and there are subtleties to all of this, and there's percentages and numbers. And when I walk into a roll call, I've got about 5 minutes, right, to have a conversation with officers. And if I go into a very lengthy explanation, they either glaze over or wonder, right, what exactly is his point?
Well, you have to be able. This stuff can get very arcane and difficult to explain, and we have to be able. Part of the challenge we are going to have is figuring out, just more globally, how you explain this to the. I mean, if it's difficult for your members to digest it, just imagine the voters who are going to vote on this. And part of our challenge is to be able to figure out how to do that in a easily explained and understood way.
Well, I think Ken's statement is that it's the same amount of money. It's whether it's compressed or drawn out. And so it does make a difference in terms of the initial outlay, but it picks up towards the other end. So, I think that's one way to explain what's happening.
I guess the other thing that I don't understand is under FPDNR, if I work 25 years, it's 2%, 2.2 to 2.8% times your average salary times your number of years, and that's a dollar amount that I will receive as a pension benefit for the rest of my life. And I can actually go online and compute that right now. And what I still don't know is under OPSRP, are the benefits the same? Is there a loss in benefits? That I still can't answer.
I'm trying to ask that in forms of, have we done a valuation that just is a numbered comparison to OPSRPs to our system?
The work that was done by Milliman did not look at more details beyond a normal retirement age and a set years of service for both the pension benefit and the individual account plan benefit. So the answer to that, Commissioner, is no, we did not go into that level of specifics.
There are police officers and firefighters already in the OPSRP. And you said, that overtime is a consideration that you can add. That's part of the benefit?
Average salary.
Yeah, final average salary calculation in the OPSRP plan, I believe, as I understand it, does treat overtime differently than it does in FPDNR, where there is for an average for the work unit can be rolled into the final average salary. And you're right that there are public safety organizations throughout the state that are in OPSRP now that had to go through the same conversation with their members about what the benefit is relative to prior Tier 1 PERS, Tier 2 PERS, and what OPSRP is. And their OPSRP plan is OPSRP at 6%. There's no one in the state currently that we're aware of pays anything above just the 6% contribution to the IAP. So a 9% contribution is actually an increase in benefits relative to what others in OPSRP program throughout the state currently receive in the public safety side or general employment that way.
Getting to Randy's point, is there any way to quantify, for instance, statewide, how, for instance, overtime pay the final year would impact retirement, so that you could actually go to have a fiscal source that's black and white to look at, so that it can show members that, or any of the other benefits? If the average retirement age in Portland for police and fire is 53, what is it for the rest of the state? And how does does that require them to work longer? For instance, is the average age of retirement 28 years, or there seem like there's some statistical things out there that you could bring in to demonstrate for Robert and Paul to their people how does this translate into practical, and base it on some experience rather than just on our estimates or projections.
I think that there probably is information available at the statewide level. Certainly the PERS actuary is able to develop that. The Milliman actuaries that worked on this particular project are pretty familiar with those methods as well, and could probably do additional work to try to give some more specifics to that. Clearly it's a different pension plan than the FPNR system, and it is going to be more complicated because it has a few more moving parts, but it's also the same pension plan that all the other public safety employees work under in the state of Oregon.
But, it seemed like certain factors like the overtime, it wouldn't make any difference what the system is. The fact is that's an additional benefit that goes into their retirement. So if that bumps up their retirement, which I assume it would from a baseline, then it would make a difference if a firefighter is in a premium paid position. And assuming there must be an average overtime that firefighters get per year, that could be actually computed out so that at least we could translate the percentage change to this system that we're considering here.
And that was taken into consideration by Milliman when they did the numbers that are shown on these tables for the pension benefit. They looked at average overtime and did that in terms of factoring it into final average salary and pension benefit. It's just not broken down into its components. But I would imagine that based on the information that is available, that could be done by Milliman for us.
And did they look at the average retirement age at the state?
I don't believe that they did, Mayor. But again, they could and provide that information as comparison as well.
Well, I think Robert's question's a good one. He's got 5 minutes at roll call. What do you tell folks in 5 minutes? And I think you got to give them something concrete to look at. And to me, I look at the entire system. Is it equal to or better? In the 50 or 53, is that outweighed by other factors that would help increase if someone chose to retire at age 50? So that's the information I don't have. So I'm curious about that.
And, we will have to work, obviously, with the associations as well as with our citizenry to distill the essence of these reforms into something that's readily comprehensible.
Aside from the retirement, our two main concerns on the disability side, one of them is putting our firefighters and police officers back to work. What reassurances do we have from the city that we can get people back to work and make the bureaus more responsible for our members that are off? We've obviously made some big steps at the pension board already and saved a lot of money. I'd like to continue that, and if this thing goes forward, we obviously like some, reassure our members that if they do get hurt, that there's a spot for them in the city. So that's one issue. The other issue is if we're going down this road of a new plan and we're sort of copying workman's comp, there are some inherent rights to workers on workman's comp on appeal rights. We just a little bit nervous that if a person gets denied their claim, what appeal rights do they have under this plan? I don't have the answers, but that's something that we're concerned about, that they have some type of appeal rights that if their claim is denied. Those are the two main areas.
In Prototype B, there is the initial decision is made by the administrator. That's appealable to a hearings officer, and then appealable to the circuit court. So that's the present route of appeals.
Yes, that's what's on the table now. Under workman's comp, after it goes to a hearings officer, a member has a right to appeal it to the workman's comp board. Under this model, we don't have that. And that's the part that makes me nervous about what rights they have that we don't have. And I don't have the answer, but we're just concerned about it.
But the hearings officer here, as I understand it, is in place of what the workers' comp board appeal would be. In other words, there's a determination made by the administrator, much like the staff at workers' comp if you got hurt. And then if you're not happy with that, in that workers' comp, you appeal to the workers' comp board. In this proposal, you would appeal to a hearings officer versus the board. So I don't see a lesser appeal, just kind of, it's different.
It may be different. When I'm out into the companies, and that's the same questions they're asking me, and I don't have a defined answer yet, what their rights are until we have the final discussion. But it is a concern to our members, and I just want to bring it forward.
So is your question one of, not one of process, because you've seen the process prototype, haven't you?
Yeah, I've seen it.
So your question is, within the process, what is the criterion in terms of what's used to decide? I'm not sure. I want to make sure that I understand your concern.
I think he wants to be able to appeal to the Board of Trustees at some point in the determination process, and this doesn't provide for that.
Is that accurate? Yeah. Okay. And why do you want that right?
Well, I think a member, again, like in workman's comp, if they go to a hearings officer, if there's a mistake made, they have the right to appeal to the board. And I think if there's a mistake made in our system, there should be an avenue for some type of avenue so you can have your rights and appeal to somebody. And it would be naturally go right back to the board. Since they make the rules, it'd be nice if there was a rule that was violated that the board can send it back to the hearings officer. To me, it's common sense, but if I'd just like to see that.
I think a guiding principle throughout the Reform Committee's work was that the new board would have no role in the decision-making process under the prototype. that we're coalescing around.
But it shouldn't be, I would hesitate to explain it that way. I would explain it more that your concern is that the member that is injured have some protections and avenue of redress. And I agree with that. Well, I think we might have a difference of opinion as to whether or not the Board of Trustees provides that degree of protection that you're looking for. My experience has been, frankly, that the courts have been really good in interpreting what the actual language of either, in our case, the charter is, or in the workers' comp case, what the statute is, and have been very fair. And I say that with having some amount of experience in that. And if I thought that we were entering into a system that put injured firefighters or police officers at a distinct disadvantage, I would say so. But I don't think that's the case.
I mean, Commissioner, I get what you're saying about having fire and police trustees on the review committee, but if the prototype is going to a 5-member board, it doesn't necessarily have to go to all 5 members of the board. I'm just looking for a shortcut to, instead of going to court and costing everybody a lot of money. I don't have the answer yet. I'm just exploring some different ideas.
Are you suggesting the potential of having non-beneficiaries be the recipient of that appeal process?
A possibility.
Well, I mean, I guess I would prefer, if we're going to insert another layer of review there, that there be a 3-panel hearings officers. You know, you could appeal from your initial hearings officer to a panel of 3 hearings officers, and from there go to judicial review. But I still believe that it was envisioned that the board not have a role in this, and whether it's 3 or 2 members, I want to adhere to that. But I'm more than willing, if that's where other people want to go, to insert that additional layer of review.
Dan is just always caving into the unions. Trying to hold fast here, and
like
once
a
again,
3-panel hearings officer board that would review the decision of the first hearings officer.
Which is what we do in our procurement process when there's a protest on a contract. We have
how do you
3
pick the
persons.
3 hearings
I
folks?
don't know how they do that in the procurement process.
Purchasing director picks them.
Oh, the purchasing director, there must be some criteria.
There's probably some criteria.
Yeah, you've got 2 outside people and an inside person.
What is the rate that those decisions are appealed? Do you folks know? Is it half, 1/10? Paul, you've been around a long time
Not
on
very
that.
many.
Not very much.
Small.
In terms of costing it out, the hearings officers are expensive. Even if you have 3 hearings officers, what is that going to cost us in terms to provide that additional assurance to you folks? Because when I look to see the different steps on those 2 things, it looks like there's the same number of steps. It's just done differently.
Well, and to be clear, you have a determination that I'm assuming would be by the staff that would be the lion's majority of all the cases, a determination that both sides agree with. And that includes sometimes the claimant being told you don't have a claim and walking away and not filing an appeal. So I think the lion's share, and I'm going to just jump out here and say in the 90 percentile, 95, 96, 97%. So what we're discussing here is that smaller percentage. Is that pretty close, Babette?
Under current structure, yes.
So under this discussion we're having, we're talking about that group that's not happy with being denied by staff appealing, and they would go to a hearings officer. And the hearings officer, I'm assuming, would be a kind of a quasi-judicial hearing, a workers' comp administrative law judge type of person. I would certainly think that's what we're talking about. And this is a person that would understand the law. So one makes their case why they think they were unfairly denied by the staff at that level. And then the discussion we're having here is if the claimant isn't happy with that decision, where do you go from there? Do you go to the circuit court? Do you go through this 3-person administrative review? And I'm just suggesting that I absolutely understand why you'd want to have that discussion. That I don't know that the amount of actual cases would be significant if more than like 1 or 2 a year.
Our concerns are that pretty close, Randy. Is just that workman's comp rules are different than our rules,
Mm-hmm.
and if a hearings officer makes a wrong ruling due to he didn't interpret or didn't know our rules,
Mm-hmm.
we just want some assurances that hey, you didn't follow the rules. I'd like you to reconsider it.
But why wouldn't you have a circuit court judge do that? I mean, what would be wrong with that?
If it's just 1 or 2 a year you're talking about?
Well, I don't know what the number is. I know it's when you get to that level of people that disagree with the determination, it's very, very small.
Actually, this past year we've had 2 cases go to the court.
2 cases.
Just 2.
Is there,
And the board, I'm assuming, ruled adversely against the member.
That's correct.
So that kind of is my point, is that as we've discussed before, my experience is that the board is very conservative, notwithstanding, maybe the perception, but it's very conservative. It's an approach on those disputes. And that from the member's point of view, sometimes their best shot is to have an impartial judge.
you mentioned earlier the cost of going to court. Is there someone that could give us some information on the relative costs of going to court versus a hearings officer panel? Does it cost any more or less? You have to gear up. You're represented at the hearings officer level, aren't you? You'd be represented at the 3-panel. Do you have to have, is the representation at the circuit court any different than it would be at a hearings panel? No? You're shaking your head no, Linda? Who am I supposed to be looking at? You're all looking around like, I've got this head cold, and you're all looking around like I'm not making sense. I bet.
My sense would be that.
Babette, you may want to come up front, but so we can hear.
Linda Jefferson may be able to provide better information about what she experiences in workers' compensation. I would think that the cost to the city or to the fund would be fairly similar to gear up for our expense of attorney expense in representing the fund, whether it be before the court or a board. My understanding of what Paul is suggesting here is that they get 2 bites at the apple. They would get an ability, a member would have a decision made by the administrative staff. If we deny it, it would be appealed to a hearings officer.
Right, from their expenses are, do they have to have an attorney before circuit court that they don't have to have at a hearings officer? Can you imagine, based on your professional experience?
I would highly recommend they have an attorney representing them if they're going forward to probably any of those phases. We do see a fair number of unrepresented claimants now appearing before the board.
So what you're saying that their representation of advice at the hearings officer level and at the circuit court is about the same?
I was referring to for the city's side.
I'm trying to get...
For the members' side, they probably would be perhaps spending a little bit more in that regard. Backing up a step, my point was if you add the step that Paul is suggesting, the cost will be a little bit more on both sides, potentially, because you've got one more appeal avenue that you wouldn't have under the prototype being suggested. However, it is what workers' compensation members have, as in my understanding, is staff, an ALJ, and then you can appeal to the board before you go to the court. So
And And are we
They have the
proposing that this process be in the charter, or is this under administrative rules?
It should be in the charter.
Thank you.
So Randy, were you suggesting something different, or were you saying stay with the original prototype?
Well, I mean, I think.
Excuse me, Linda?
Yeah.
Clarify one thing, I'm sorry. In the 3 steps are different, but there are 3 steps in both. And so I think it's important to recognize that in workers' comp, you don't go to circuit court. So
Oh.
you have, you go to, you have the decision maker by the administrator, then you have an administrative law judge, then you go to the workers' comp board. And from there, you go to the Court of Appeals if you continue appealing. You don't go to the circuit court. So the circuit court here would be the equivalent of the workers' comp board, not the administrative law
I
judge.
see.
You'd have the administrator, the administrative law judge, and the circuit court, and then from there, you could go to the Court of Appeals. So there's 3 steps before the Court of Appeals in both, and it's the circuit court substitutes for the workers' comp board, not the administrative law judge.
And how do we determine who the administrative law judge is?
You would hire or appoint someone to be that. You could have a panel of people who rotated. I would think you'd want someone who becomes familiar with the system, but there's a number of ways you could decide to do that.
Kind of like the way we hire hearings officers now for
Right.
land use and stuff like that. Yeah.
What?
Oh, we do? I mean, we don't have one full-time person? I thought we had one full-time.
Well, certainly in the, for instance, in the drug and prostitution-free zone areas, we do have a hearings officer that hears all of them.
But we wouldn't do that in this system. We wouldn't have one full-time. We're not contemplating hiring a full-time person.
I wouldn't think so.
No, I think you'd probably contract with one or some group of people who would be available on call at the time you needed them.
But that wouldn't be built into the charter. That would be an administrative rule.
I would assume it would be by administrative rule.
So I'm counting 4 steps on the status quo and 3 steps on the prototype. You've got
So
administrative.
look, there's a Court of Appeals, which isn't written there.
Okay.
That's the 4th step.
That's the 4th step. Administration Expediting Committee, Board of Trustees, Circuit Court is the status quo. And the prototype is Administration's Hearings Officer, Circuit Court, and Court of Appeals.
Well, yeah, and the Court of Appeals would follow on the
Regardless?
current, yes.
Okay.
After the circuit court, you can go to the Court of Appeals.
And what are your
And-
thoughts, Linda? Do you have any thoughts on the notion of having a 3-panel in between the hearings officer and circuit court?
I think it's really a policy matter. I think it would be an additional step that's not, one more step that's not in the current system or in the workers' comp system. It would be additional cost, but it's really a policy decision of how
Do you think
many
it
steps
provides?
you want.
Do you think it provides safeguards that without it? Do you think it provides valuable safeguards for the individual? Do you have any opinion?
I tend to agree with Commissioner Leonard that the circuit courts are able and competent decision makers, and they understand lots of different legal systems and could deal with it, but that's just my opinion.
Thank you.
I mean, ironically, my experience was when I was on the board that when people appealed to the circuit court, they more often prevailed, which by definition meant the board had denied them. And they found, if you want to characterize it this way, they found their justice in the court system. And in fact, that's the lion's share of my memory of those cases, was that oftentimes the board was overturned and they were sustained in a judicial setting.
I know that last year we had none that went to court, and this year we had 2, and it was 50-50. One lost and one won. So but that's not a lot of cases to have a track record with.
I think that's I think that is fairly consistent, though, with my memory.
Thank you. Thank you.
Thank you, folks. Are there any other issues remaining?
Those are really the issues, the extant issues.
How many, I guess the other maybe obvious questions on the hearing officer issue is, how big is our pool? And is there a problem with having enough of these to make a panel work or not?
Can you answer that, Babette? Could you come up and answer that?
And at some point, we have Joe Gray here who asked me for the hearing if he could come up and make a couple observations, who represents the retired fire and widows.
I'm sorry, could you repeat the question?
I guess just another obvious question around whether we should have a panel of hearings officer in between the hearings officer step and the circuit court step. Is access or getting enough hearings officers ever an issue?
We've begun some research on this subject because actually under existing charter language, the existing board can appoint a hearings officer to conduct hearings, and the board is moving down a path of doing that under existing charter language. There is a state-run office called the Office of Administrative Hearings. They have approximately 75 hearings officers. That office has indicated they do hearings of this nature and would have sufficient staff for us to do an interagency agreement with them. Their rates are quite competitive, and I think it's at this point in time it's the option that the current board is looking to probably choose from a panel of those. If that answers your question. I would like to maybe make one point if I could. The Board of Trustees has had for quite some time a list of what we call housekeeping issues on our list of things that we would like to see perhaps addressed in a charter change. I don't think that list has been entirely reviewed by any of the committees, and if given the opportunity, we would like to sit down and discuss that list of housekeeping items at some point, and just putting that out for your consideration.
I think that needs to be done. Often it's those housekeeping things that cause problems. So I appreciate that. And how would that happen? Commissioner Salzman, would you take that on?
Yeah, I'd be happy to sit down with Babette or trustee
Did you
members.
hear what Babette was saying, Commissioner Leonard, in terms of there are just a number of issues that the board, FPD&R board says are housekeeping issues, just cleaning up the language of the charter.
I'm sorry, Mayor, I'm focused on these water droplets Commissioner Adams is staining the desk with.
Oh, jeez.
I can see you've got your priorities
After
straight.
you've got that settled.
But,
Oh, no.
Katz is on the TV
I think
yelling
that's-
at
I'm
me.
happy to.
I know Mayor Katz is watching right now, so he can expect a call right after this.
Sorry, Vera. There it is. Put it on my
I
finger.
mean, I think, where we go from today is really to come back with a resolution that council directs the city attorney to draft charter change language. So the resolution would contain all the elements that we have here, plus if there's other housekeeping stuff.
Well, but I would recommend the one thing that we need, the devil's in the details on some of this stuff. And I would strongly recommend, Mayor Potter, that you appoint somebody. I would think it'd be like Austin and Linda Mang to sit down with the representatives from the unions to work out these finer points. Because it sounds like in concept we have kind of an understanding where we're going, but it'd be really important, I think, at this point, to get somebody that all sides are going to be comfortable sitting in a room that sits down and actually starts drafting some of this stuff. That is going to be the really important part, and we don't want to skip that really basic part.
This being the charter language or the direction to the city attorney's office to create the charter language?
Both.
Both?
Both. I mean, my experience when we did this 20 years ago was that was a key part of the success. And after everybody had a concept of where they wanted to go, really the most work was done getting that in language that people agreed represented what the direction was.
Given the direction that we've had today?
Mm-hmm.
So a wordsmithing group.
Wordsmithing group.
Wordsmithing and working out some of these finer details, but it would be important to have a designated person that represented the city, if you will, that was the go-to person, and but that person needs to be hooked up with somebody from the city attorney's office. And then I would say, just to make sure we're all on the same track and still heading in the right direction, we do what we're doing here one more time after they have a rough draft or pretty close to a document that we can all discuss in this same forum.
Well, we're scheduled for June 7th at 2 p.m.
That would-
So I guess we could get that group together and direct them to have back to us.
Well, I'm really thinking of a small group, like a person from fire, a person from police. If they want some lawyers with them, a person from the city and an attorney, and sit in a room.
And the committee.
Well, I think that probably happens after we pass the resolution saying this is what we want to see, because that's when the drafting
Well,
begins.
you want to make sure that when you pass the resolution, though, everybody is agreeing that we're headed in the same direction.
I don't think it hurts to do both in a parallel track, to start early and do the resolution. It's just the more time we take to vet out the language.
As long as we vote on the
better off
resolution
we'll
that
be in the
directs-
smaller committee
Well,
makes.
again, I will repeat, I am less concerned about having a date by which we do something than I am being successful. I mean, you've got to be successful.
But we know that there's a certain timelines in terms of getting this on the ballot, and it has got to
August.
comply with that.
Right, and we should have that date red lettered.
Well,
and then
but we
just-
also, passed a resolution that committed ourselves to act by June 1st, to send something to the,
So do you want to act by June 1st, or do you want something to pass?
well, I want to act by June 7th, but I want to keep the ball rolling.
Well, you have to remember what the goal here is. The goal here is to get something on the ballot in November and get it to pass.
Yeah.
That's my goal. And what I'm suggesting is that we are very thoughtful at this point about making sure we're keeping everybody moving in the same direction. And if you're hearing or observing somebody begin to fade, you have to focus on that and get them back in. And
Are the unions willing to make that kind of commitment without having gone out to their membership? Do I see heads nodding? Oh, okay. Go ahead and caucus and let us know, because I think that, if you're willing to enter into that kind of,
can we hear from,
well, it's
I guess, I'm really confused as to what we're doing here, because we had the independent review committee. They spent a year looking at this, and then, largely at Commissioner Leonard's suggestion, we set up the reform committee to do exactly what you're saying they're supposed to do now, which is get everybody in the room.
That's not what we're
work
doing.
on the charter language, and we passed in a resolution. We said,
right.
complete your work by June 1st.
No, we got general recommendations, and what I'm suggesting is we now, it appears, has somewhat of a consensus.
I think we do.
Okay, so what I'm saying is, building on that strength, make sure that we have our partners in the room so that what our consensus is reflected in a document, that it reflects what we've discussed here today.
Actual language.
The actual language, that it.
Well, I'll have, the charter language drafting process is going to be extensively participated in, I'm sure, by all parties. But we need a resolution to adhere to our earlier commitment to act by June 1st, but also to frame what it is, to end the permutations of committee discussions upon committee discussions. We've now locked in.
We talked about having a report back by June 1st. That's what we talked about. We got a report earlier than that. So as far as I'm concerned, we're ahead of schedule.
I think the resolution's committed us to act by June 1st.
When you say just
send something to the ballot by June 1st.
No, I don't.
by way of clarification, when you
And we're not asking that. What we're going to come back with is a resolution saying, here it is. Here's prototype B. Here's OPSERT.
That's what I'm saying. They need to be a part of development.
Okay,
One way
but
or
I'm-
another.
resolution, what
But
puts
I'm going to still work on a timeline that we're going to vote on something on June 7th.
Well,
Dan, is the resolution you're talking about what actually goes on the ballot? Or is
No,
the
it's to
resolution-
direct the city attorneys to draft that language.
Okay. So the resolution could also include a call to action to create a little wordsmithing committee that would put the language together.
I think that'll happen whether we call for it or
I
not.
think you guys are basically agreeing.
No, I can tell you, based on my experience, we are not agreeing.
How? Are you not agreeing?
Well, because Dan is overlooking a very fundamental part here, and that's making sure that every document that this council looks at from this moment on is bought into by all the partners. And it's a mistake not to understand that that's a critical part of the success in November. So I detected, I'm saying I just picked up that there was some concern down here at the end of the table. I think it's all workable, all fixable. And what I'm suggesting is the way you fix that is not any other way but pull them in a room with a city rep and one of our attorneys and develop the resolution that we'll vote on that reflects what we discussed here today and
That
works
seems
through
very
any
doable.
misunderstanding.
That's what I wanted to do.
I think that is. I think, though, and I remember you saying this a long
If
time
the
ago,
charter
Commissioner
language
Leonard,
would follow.
is that if there isn't that consensus, that we will make that decision.
Yes.
And I'm still standing by that statement as well.
As am I.
We will make a decision if there's some I's that need changed or crossing of the T. We'll go ahead and make those decisions.
Yes.
Okay.
Absolutely.
Is that fair?
And I thought
Yeah,
that was,
like I said, as long as it's consistent with bringing a resolution
So
back on the
then what is the direction of the council? Is to put together that particular work group, and I'll appoint, and it probably will be poor Austin, but we will go ahead, and then they will have something back prior to the June 7th hearing.
A resolution.
A prototype resolution we could look at.
A resolution which calls for the actual writing of charter language.
Yeah, well,
and frames what the charter language is.
yes.
Correct. I agree.
but consistent with us making sure all our interest groups are being heard, that Joe Gray is here from the retired folks and wanted to say something, so I'd like to.
Please come
We also
forward.
have City Club folks here.
Yeah.
And reform.
Anybody that's interested that wants to
Did we
speak
have a
here today
sign-up
should
sheet?
be able to.
Not for work session. Okay. Thank you for being here. Would you please state your name when you speak for the record?
Yes, I'm Joe Gray, President of the Portland Retired Firefighters and Widows Association. And we have some problems we feel with our widows under the old plan, which is a last man's club. No other people can get into the old plan. Everybody comes in a new plan and now a newer plan, I see. But these
So you're talking about the plan that existed prior to 1989.
Yes.
Right, from 1948 to 1989. And so we have some surviving spouses who are placed on an annuity table that diminishes their recipient of the what they get from the fund by a substantial amount. I mean, they're
Younger than the
if they're
the
younger,
member.
if they're the annuity table is spells out that they're younger than their spouses, and when as the number of years difference is greater, then they get less and less, and they get down to the point where they receive about 18% of what a firefighter, a first-class firefighter. Now, everything they get is predicated on a first-class firefighter. They don't get no benefit from any raises for specialty situations or retirement in rank, as we call it. But, so it's a thing that they get down to about 18% of a firefighter scale, which is in today's world is pretty tough to get along
So
on.
if I actually remember this provision, so what happens is if you have a firefighter or police officer that married somebody, say, 20 years younger than them, and they were married for 40 years, and the person that was a retired firefighter died, then the amount that the surviving spouse got is 20% less than a very exact same circumstance where a firefighter married a woman his age or older, or a woman that was a member married a man 20 years or older, and when that member died, the retirement amount for the surviving spouse is 20% higher. And the difference is not based on longevity of the marriage. It's not based on longevity of the service. It is only based on the surviving spouse being younger than the member. There's no other criteria.
Why would that be?
I'll tell you why that Joe probably can confirm this. When I asked as a young firefighter how that could be, I was told that the people that wrote the act in 1948 were concerned about these older firefighters and police officers marrying young women for the sole benefit of bequeathing them retirement. And so they wrote this in to discourage that from happening, was the explanation I got.
Is there a tie into what we're discussing?
Was this
There's a
discussed
tie-in
earlier?
in that
IRC?
it goes on the ballot to amend that provision of the charter. And what Joe is suggesting, that this chapter also include an amendment that does away with the disparity based on age for retiring spouses.
Is that one of those housekeeping things that you mentioned,
No,
Babette?
that's going to cost some money. Somebody like Ken, you want to?
Well, I don't think it can cost very much
Probably
more.
with this particular thing, but it's not unusual in a pension system to have the age of the surviving spouse be a factor in determining the pension benefit. It's done in the PERS system because the fact is, again, it's this pot of benefits that have been earned distributed over a lifetime of the member and or the beneficiary. And for the system to provide comparable benefits to everybody, it's that same concept about making an actuarial adjustment based on mortality tables, current age of retirement, expected life in retirement, and expected life of any beneficiary of retiree. So the fact that there is a haircut for a spouse that is a different age than the member is not an unusual pension actuarial concept. So I just want the council should be aware of that.
And I really want to sort of try to keep this separate if possible, so that because this is going to be difficult enough. Is there a way to bring that issue up in another format?
The council historically has done amendments like that as standalone provisions. They referred to the ballot over the years. And I'd certainly be interested in talking about that more. I think as a practical matter, when you look at the old system and the old formula, what Joe's actually talking about, when you get down to 18%, you're talking widows that are probably getting like $400 a month versus maybe $700 a month without Social Security. They typically do not have Social Security. So that you have to keep in context that maybe Babette actually has numbers. Do you know off the top of your head, or do you want to give them to us? Okay. I think if you actually look at the numbers, you'll see that we're talking about a significant impact on the very low end of the scale for what is certainly a small group of widows out there. I don't know. Do you know how many we're talking about?
No, I don't. I talked to Babette about this some time ago, and the feeling was that there wasn't a major impact of any kind on the fund itself, and it was something that could be dealt with as far as basically a housekeeping type of situation. So, and that's why I brought it forward. I think that the fact that they don't get Social Security and the city saves approximately $8 to $10 million a year by not having to pay into Social Security for these members, and that there would be something that on the table possibly for this particular group of people, and it just has to do with widows or surviving spouses under the old plan. And
that are younger than the member. So
Right.
it's a small. So maybe we could get Babette could get us that number. How many people we're talking about?
And what would be the impact on the fund? And we could, we could evaluate that. I just don't feel like I've got enough information to make a decision on that. But I think you make a good point, Joe.
I have some copies of the proposal. If I can leave them, you can take a look at them.
And would you make sure that Babette Means gets a copy?
And I'll make sure that Babette gets one. Sure.
Thank you.
Right. Thanks.
So we also have City Club representatives here.
Yes, please come forward.
City Club representative and also a member of the Reform Committee.
Hi, Eva Schweber. I also just want to commend you for the work you're doing. I know this is very, very challenging. And we made a commitment to support voter education, so I agree with Commissioner Leonard that we really need to make sure that the language is clear and that we find a way to explain this. And I want to put City Club out there as any support we can provide within the educational support. We're happy to help. The only other thing I want to add is if this committee is formed to really hammer out consensus, I understand the desire to keep it very small. I would recommend that you do have a citizen representative. I would be happy to serve on that committee. I'd be happy to have someone else from my study committee serve on that. There's also Jeff Furnish, Judy Clark, and Judy Rice. So there are, I think, an adequate pool of citizens who have participated in this process, understand the issues, and I just really would like to make sure that there is a citizen voice as those details are hammered out. Thank you.
I agree with that. Any problem?
No, in fact, we had met earlier, and I told
Okay.
her that I agreed with that.
Is anybody else to speak to any issues? I think yes.
I'm Susan Dobroff. I'm the former legal advisor for the pension fund. And I also worked in the workers' comp system. And as you were talking, I just really want to point out one thing about the appeal rights and a comparison to workers' comp. In workers' comp, the staff makes the decision. If the decision is denied, it goes to the administrative law judge, and there's a trial-like setting. If that's denied, it goes to the workers' comp board, and that's de novo review, which means the workers' comp board looks at it fresh. They look at the whole issue. They don't take new testimony, but they look at the whole issue. So there's two really meaningful levels of review where the member can put out all their information and make all their arguments. In the prototype system, the administrator makes a decision. If the member's denied, they can go to the hearings officer. That's a trial-like setting, so that's meaningful. If that's denied, it's a writ of review to the circuit court, and I handled the cases under the writ of review, and it's a very narrow, there's no new evidence, it's not de novo review. There's a very limited basis on which the court, the circuit court, can modify the hearings officer's decision. So that's not comparable to the workers' comp board. It's a much more, or the current system, it's a much more limited type of review. And I think part of what the members were saying is that they need to have two settings where they can make their full case. And under the workers' comp system, that is possible. And I don't think that really is under the prototype system as it's currently being proposed.
So what did you think of Dan Saltzman's idea of this three-person forum after the hearings officer? Would that accomplish the same?
As long as the three-person hearings officer group would be able to look at the whole record and would not be constrained as to what they could, that they could only make a decision to. The way it is with the writ of review is the circuit court is not to substitute their judgment for the lower decision making. And the way it is under workers' comp, the workers' comp board is free to say, looking at the evidence, well, we just think that the administrative law judge got it wrong. So there's two levels of review. And as long as Commissioner Saltzman's proposal is that the three-person panel would be able to look at the whole thing anew, not take new evidence, but look at the whole situation, then it would be the meaningful level of review.
So could we have this small group that's working on this discuss that further to see if there's some?
Yes.
I mean, I'm interested in a system that's fair to all the parties. And is it your opinion that the three-panel would provide the comparable amount of fairness that's available under the state system right now?
Yes.
If it was de novo review.
If it was de novo, right. Thank you for your testimony. It's very helpful to me.
Yes, thank you. I think we were going to hear from the unions. Well,
we let them talk.
In terms of working with us to craft the appropriate language for the resolution and charge to the city attorney's office regarding charter language.
Robert King for the Police Association.
Paul Cora, Portland Firefighters.
You know, we have appreciated this review process that's resulted in the recommendations that we've talked about today. Today really is the first time we've ever heard 3% as an additional contribution to the IAP, and that's designed to be a bridge benefit or an additional benefit. There's still questions about that. I think the appeal issue continues to be a concern for us, and so I just want to make the point that we still have some things that are new, really, today that we need to think about and talk some more about.
You think this process that we're describing that you would participate in could address those? From what you heard today?
Possibly.
Sounds to me like from the questions you've raised and the sentiments that I've heard from the council, there's a potential common ground in there.
There may be. I guess we just need to take some time and talk among ourselves.
But are you willing to commit to sitting down to see if you can work out those concerns with City Club member Austin? And
I just feel like I just want to be really clear that back in May, Mayor, we made a commitment to you to work constructively in a process to work together to reach what is the best possible ballot measure in November that satisfies everyone's concerns. And we've been inching our way along constructively and meaningfully. And I just, at the last few moments, I just want to be cautious and careful. There's 950 people I'm responsible for, 600, 700 for Paul. So I just want to pause briefly after this discussion prior to making any further steps, is all I'm saying.
But I want to be really clear, at least from my perspective. What I'm suggesting doesn't commit you to support anything. It does involve you in making sure that whatever concerns you have are reflected in the resolution we vote on in June. And after that, if as far as I'm concerned, you haven't made a commitment to support anything. But frankly, my view is you're more likely to support something you've had a hand in crafting than you are allowing us to do it unilaterally. So I would really like to put you on the spot here today.
I like that a lot. I like being put on the spot. But we're not going to commit right now, and only because I really do want an opportunity to talk some with Paul before we make any commitment in moving forward. We may, in fact, that may be the decision, but I would like a brief pause and a chance to talk.
Well, I think the other side of that coin is that we proceed without you, and that kind of jeopardizes Randy's point about making sure So it's important that we get this issue before the voters, and I understand where you folks are coming from.
I don't have time to talk today.
You want us to take a break, a 5-minute break now?
Why don't we just whisper in each other's ears?
Okay. That's fine. Go ahead.
All right, fine. Let's go back and sit down.
Don't bother us. Don't let us bother you.
Okay, fine.
I think the other thing I'd like to hear back from you all is what kind of information, what kind of questions can you expect your members to have that we need to be able to provide them? If it's an online calculator, whatever it is. I think that's a very fair question.
But before you get there, you have to go through this very important process of the next couple weeks so that they understand better the answers to the questions they have. So that's a good idea, but we want to wait till we produce this resolution, which I will predict will answer a lot of the concerns and give us more guidance as to what we should prepare for. So
I'd actually, a small point of disagreement is I would try to do both at the same time, because I have a feeling that if we come up with some policy approach but it falls flat, you're going to have a hard time selling it. So I agree that we've got to make...
Well, we can't sell anything that they don't support, so...
And we can't necessarily get their support until we have it in plain English, so we're kind of...
Right.
I'm just saying...
I appreciate that.
We can all struggle around as much of the issues as you can, and...
We can get started today if we can get the numbers from Ken and give it to our accountants so they can look over the numbers that you gave us today, because I'm frankly a little bit lost in some of the numbers. I'd like to get our opinion.
So is that clear that they can ask for and receive information to the questions they have?
To clarify.
Yes.
The existing information and decisions that we've made.
Yeah.
Yes.
So if they go to Ken directly, he's free to share with them.
Thank you.
Whatever the questions are, they need to clarify.
Or anyone else.
Or anyone else.
Thank you.
Thank you.
Great, thanks.
Ken, why do you look weird over there?
I'm fine with whatever information I have. Some of the information we may have to create, we may have to ask Milliman to do some additional work for us. That's the only question.
That's important to do.
Yes.
Very important.
So what is the date that we would expect that product back? If we meet on the 7th, should it be the 6th? So
I mean, I don't remember. I'm hearing Commissioner Saltzman saying something about we've agreed to the 7th. I don't know. What's that based on?
It was based on the resolution we unanimously adopted.
What did it say that makes
committed
us?
ourselves to act by June 1st to send something to the November ballot.
I don't remember it saying that. I mean, I remember us getting
I
a
can get
report
you the
back.
resolution.
Get me the resolution, because I don't think that's what it says. I think we're supposed to have a report back by June 1st. Because I remember asking specifically the question about what the deadline was to get something on the ballot, and it's in August. And I'm
Well, speaking for myself, I think, it's time to really, get the product.
well, you are
refined.
speaking for yourself, but if there's
Well, I know,
a
but I
majority
mean,
here that
No, but I guess what I'm
agrees
saying is I
there's a
propose to have
process.
something at the June 7th council meeting that
Well, you did,
all
but
of us.
that's
a chance.
not, that's you, and that's fine,
Well,
and you
okay.
have that right. You can propose anything you want June 7th, but that doesn't mean that's the deadline for the council. I mean, I'm more interested in working through this process and getting consensus and being successful than I am meeting
There's
a
still
deadline.
a lot of steps between passing a resolution framing what will go to the ballot and actually drafting the charter language as to what that language will say. So it's not like we have
what are
till
the
we don't have
timelines?
till August.
Linda, do
No,
you
I
have-
understand that, but we don't have, June 7th isn't the
Linda,
deadline
do you have the
either.
timelines for the submission of a charter change to the, for the ballot?
It's got to be filed on July 27th. The council hearing is on August 2nd.
So the final product would be voted on August the 2nd.
At the latest.
On the latest.
latest. And I
And
suggest
of course,
we not,
being
I
a
suggest
summer
we
schedule,
not,
I
yeah.
wouldn't want to get it that
I don't
close.
disagree
we
with
don't be
that,
operating
but
on the latest.
I'm just, Commissioner Saltzman keeps saying the deadline is June 7th. This is the first I've ever heard that. I mean, my timeline that I've been working on is we have to have the report back June 1st, and then between then and our other deadline, and it shouldn't be right up at the end, I agree with that, but at some point in there, we need to have an agreement what it is that we put on the ballot.
Right, and that's what I think we need a
But
resolution.
do we need a report back on June 7th? Yeah, I think we do, to keep this thing moving.
That is what the resolution calls for. I agree. It doesn't require that we have a resolution in place saying this is what we want the city attorney to draft.
So it sounds like there's agreement that we have a resolution to act on to keep the process going. That resolution could include the committee that would move on, and it could shape, to the extent that there's agreement on council, sort of the policy issues that that charter language would include.
Well, I suspect at the end of this, we will have to make some decisions.
Yeah.
I think we did today.
Well, but I mean.
My sense is we've made some decisions, very important decisions.
There'll probably be a few more, though.
And I'm just not getting the whole resolution thing that Commissioner Saltzman's focused on. My thought is that today, based on today, we do just what you did, direct Linda and Austin and anybody that we can drag into the room with us to start actually writing what the proposal will be. And the idea being getting to charter language. And I think we're doing that today.
I think that's what we've been doing for the past 3 months.
I don't think there's any harm in having a resolution that creates the committee memorializes what we're doing moving forward. Just the fact that we have some misinterpretations of what the last resolution said probably speaks to needing to refresh.
Right. I agree with that. But the resolution that we adopted before required we get a report back by June 1st. We got it all. We've already gotten that back. We've complied with that resolution. And now we're in the process of using a process to get that into charter language. And if you want to do a resolution to that, that's fine. But there's no mandate that something be on the agenda June 7th.
Well, my sense is that if I'm going to work to try and pull this group together, there are areas where I think there are agreement among council and the stakeholders. There are some areas where we haven't finalized agreement, but we've certainly discussed what the issues are. And so my sense is that in this small work group, we will try and find consensus on those remaining issues that have not yet been finalized. And that may require some conversations with you as a council that I would have individually in terms of finalizing those areas, and then working with the citizens and with the stakeholders. My sense is that we should be able to do that fairly quickly, and that ideally we would be able to get that information back to council in time to file for a June 7th hearing, which would be the end of the week, next week.
My suggestion would be that given that you've got some housekeeping items, that we actually schedule another one of these at the appropriate place, and you can put that in the resolution, because there are going to be some issues here that are going to be new. And where there is disagreement, I think we want to build in an appropriate amount of time for us to discuss those, not through shuttle diplomacy, but at this table.
I agree with that.
Danny, can you live with that?
I'm not sure really, I want to bring a resolution June 7th that frames, this is the charter language.
That's not
this
happening.
process-
Dan, that is not happening, and you need to come to grips with that.
No, I mean-
I am not comfortable coming with charter language that's ahead of where we have this work group until we absolutely have to, in my sense of absolutely have to, is sometime
I
in
guess
July.
my commitment is to a process that really works in time to get language on the charter. And my experience to date has been this process fills the available time.
Well, I'm
so
telling you,
you create
you
more available time.
You
there's
cannot
still
have
no
the
progress.
charter language ready July 7th. That's different than what you've said.
No,
You've said
I'm saying
is
a
have
resolution directing the city attorney to draft the charter language.
Oh, okay.
Say
That's
X, Y, and Z.
That's fine. You just said have the charter language ready.
No.
So what is the
resolution
direction?
saying to the city attorney, here's the charter, here's what we want in the charter reforms.
And group.
Draft it.
City attorney and group.
Sure. Anybody's invited to be involved in the drafting of the charter language.
Well, not
but-
anybody.
but-
Let's make sure we.
But no, it's come, the time has come. The time has come for the council to make the calls on some of these issues.
We
which are
are
still
doing. We did
lingering
that today,
doubts.
Dan.
And I suggest.
Yeah, so we haven't done, this is a work session. We haven't officially done that.
And I suggest that
Suggest
as part of the
another work
resolution, we have a predefined date for the next one of these so that there is discussion, there's as much consensus as there's going to be achieved with the group and the city attorney, and then we come back here and resolve any issues that remain.
On the actual charter language.
I think that's reasonable, because we did, you're right, Commissioner Leonard, we did make some very distinct decisions today, and it's where the group could not agree. And I think the next time, hopefully we will take the remaining issues and make decisions on those.
Yes.
In terms of the work with our offices, especially on the new issues that might come up with the housekeeping stuff, that's the continuing conversations on that I think would be really important. And I'm happy to continue to send Brian as an observer or whatever to the meetings.
So whoever's writing this down, do they have a clear idea what we're asking for now?
Well, I think it's Austin and Linda that we've designated. So
Okay. Do you folks understand?
I want certainly Shannon Callahan from my office. Yeah.
The only question I have is when you talk about the work session where we come back with, this, after once this finished. Is that before the 7th or after the 7th? Or is it in place of the 7th?
In place.
In place of.
It's sort of a provisional suggestion. If the work group is smooth sailing, there are no issues, we might not need a work group.
right.
But if there are issues that need to be work session,
Got it.
issues that need to be resolved at our level, obviously, I think we should have a work session on that before we have stuff in formal language before a formal session.
And so that date would be around June 7th.
Right.
That we would hold another reform work session.
I feel
Okay.
good. That's
One clarif- I thought you
No?
you reformed the group.
I thought
and
we'd do
then
the
had
resolution and
meetings.
then you have the work groups.
Is that what you're saying?
I'm assuming
The
that.
work group works on the actual charter language. The resolution frames, here's what we want.
Correct. That would be my suggestion. I'm assuming that we can come to agreement and that there is agreement around the table of what would go in the resolution. But the resolution would outline the timeline moving forward to the deadline for putting something on the actual ballot, and that there would be a date for a council informal work session to check in and or resolve any issues that could not be resolved in the work group. Does that make sense?
Yes, I
So
understood
we
that.
will have a resolution on the 7th.
Correct.
Yeah.
well, I mean, unless there's disagreement. I mean, we just said there'll be a work session.
Agreement, maybe.
It at least.
I mean, what is this fixation on June 7th? I don't get it. I mean,
As I said
we have
earlier,
a process.
this process has been characterized by,
But you're one person.
The
Dan.
available time-
There's other people here.
well, Randy,
and we-
if you were to listen to what you said back in March.
I said by August I would
Well, we can't,
agree to have something on the ballot. And I've never
wait till
said
the
June
last minute.
7th. Well, it's we
Okay,
can't.
I think we understand what we need to do. And we will
I'm sure
have
a lot
that
of us will
work.
be gone during the summer
The
at various
work,
points.
Well, then don't go anywhere. Stay here
work
until it's
session.
I'm
done.
not going anywhere.
Excuse me. We'll have that work session, and that work session will be to look at the remaining issues, to clarify the language, to then hold a council hearing on after that, that then directs the city attorney in a form of a resolution to create the charter language to place on the ballot. Okay.
Say that again?
Oh, jeez. I was hoping no one would ask that. Can someone repeat that, please?
I'd be glad to.
No, I don't want to.
That the purpose of the work session is to look at the remaining issues like the ones that we had today, make a decision on those issues and the crafting of the language, then take that to the city council, a subsequent city council meeting shortly thereafter, to craft both, to direct that resolution to the city attorney's office to prepare charter language commensurate with that resolution's direction. Okay? Okay. Do we need to vote on that?
In June.
No.
Okay, not at a work session. That's good. Okay. We're adjourned.
Thank you.